Hey everyone, David Tarras, partner at the Rossen Law Firm, head of our federal criminal defense practice. In our last video, we talked about what is the most common charge that we see the government bringing, investigating, indicting, charging people with, and prosecuting them for as it relates to PPP fraud, and that is wire fraud. We went into an immense amount of depth and detail related to the individual elements of wire fraud, how each individual element stacks up, what kind of evidence the government has to use to prove this individual element of wire fraud or each individual element. And what we're going to talk about today is probably what we see as the second most common charge when it relates to PPP fraud, and that is bank fraud. Bank fraud statute is very similar to the wire fraud statute as far as the scheme and the artifice to defraud by false and material misrepresentations. But what is most different about bank fraud and wire fraud is first and foremost the penalty. Bank fraud is punishable by 30 years and a $1 million fine. So it does have an enhanced penalty. The reason why we see wire fraud so much more commonly in PPP cases other than bank fraud is because wire fraud has that element of use of interstate wires, use of an electronic device capable of passing information along state wires across states in order to achieve the scheme or artifice, the fraud essentially, or the scheme of the fraud, the scheme to commit fraud. Bank fraud does not have that element where the main act, kind of the crime itself, is just sending a message on a device capable of transmitting messages across states, like a cell phone or a phone. Bank fraud doesn't have that element that the prosecutors so commonly rely on in coming to us as defense attorneys and saying, look, your client is in big trouble because, and we can definitely get him here because we have a text message. The text message was in furtherance of a fraud, and so therefore we have this good, easily obtainable evidence and your client's in trouble. You're not if you come to us. Bank fraud has a different kind of language, but not the easiest way like wire fraud has of basically the big act, what we call the overt act of the fraud, being just sending a text or an email. Now, specifically under the statute, what bank fraud requires, and there are many different elements, individual elements to bank fraud as well, that are similar to wire fraud. The federal bank fraud statute, 18 U.S.C. 1344, defines bank fraud as knowingly executing or attempting to execute a scheme or artifice, 1, to defraud a financial institution, 2, to obtain any of the monies, funds, credits, assets, securities, or other property owned by or under the custody or control of a financial institution by means of false or fraudulent pretenses, representations, or promises. Very similar to the wire fraud statute, but it is missing that easily provable element of a text message was used in furtherance of this fraud. Bank fraud requires a bit more than wire fraud, which is why it's disfavored by the prosecutors, because they bring the easiest charge for them to convict on, which generally speaking, at least in their point of view, the government's point of view, is wire fraud. So why do we see bank fraud so often in PPP cases, PPP fraud cases? Well, very often the allegation is regarding one of our clients making false representations, devising a scheme to defraud a bank or a lender into providing them with the loan money. I mean, it is the crux of an allegation of PPP fraud. Now, the bank itself, this being from a financial institution or a fraud being committed on a financial institution, is the big separation between bank fraud and wire fraud. Also, you don't have some of the necessary elements of wire fraud, which actually do make it a bit easier, as we discussed just a bit ago. But bank fraud, the real big change in the element itself is, 1, it does not have to involve the use of the wires. It encompasses all kinds and a variety of different kind of activity. One of them being making a false statement on a loan application, something which is actually a separate crime itself that we see very often in PPP fraud cases. Many different ways to accomplish it that can all fall within this very all-encompassing statute, this charge of bank fraud. The elements are the same as wire fraud: the scheme and artifice to defraud, the materiality, always focusing on the material aspect, because to a bank, now this is an important difference as well between bank fraud and wire fraud. To a bank, the concept of material is much less, I would say, the way the courts treat it. The concept of material is harder to prove than material in the wire fraud context. $5 of fraudulent misrepresentation in a scheme to gain $5 from a bank, very different than doing so from a person. The interesting thing about bank fraud and wire fraud in a PPP context is that they can be proved the same way. What prosecutors are doing and what we're seeing is they're saying basically, hey, if your client doesn't want to fold, if your client doesn't want to take a plea, then we're just going to charge them with bank and wire fraud, and we're going to be able to get them on one. It's not the case, but that's their logic, because really at the end of the day, when it relates to PPP, it is the same conduct, really. It's the same elements, the same conduct, the only difference being that in bank fraud, there is a financial institution that's being defrauded, and that it doesn't necessarily involve wires or the use of wires in order to do it. So bank fraud we don't actually see as commonly. Again, it's a very case-by-case basis, but bank fraud brings with it substantial penalties itself, regardless of whether the fraud occurs during a disaster or a pandemic state, a national emergency or not. The penalty for bank fraud is 30 years in prison and a $1 million fine. In the context of PPP fraud, wire fraud, and now what we're talking about here, bank fraud, are extremely serious. The way that the applications are made, the way that the government usually brings these cases and the evidence, it really looks like bank fraud can be made out right away. You made a false representation to a bank and you got the money from the bank, your scheme was accomplished, even though it doesn't have to be under the law, and that you did so through financial or fraudulent misrepresentations regarding your finances, your payroll, the other certifications that you had to make in your PPP loan application. You need to contact an attorney quickly, because as you can hopefully see in this video, we are prepared to not just roll over and say, okay, my client, you're saying, government, that my client made a false application to a bank, they got the money from the bank, it was an intentional, they had the intent to defraud the money into giving them, and defraud the bank into giving them this money, therefore 30 years in prison, $1 million fine. Unacceptable. Contact us at the Rossen Law Firm so we can protect you from bank fraud charges as it relates to the Paycheck Protection Program.